My name's Elan Dunaev. My firm is EJD Law Group. I'm an attorney. So these are my areas of practice. Construction, obviously, main reason why I joined this group. It's a construction group. Not everybody's a contractor, I guess most are, or all of us service the construction industry. So that's definitely, the first three bullets are by far the largest part of my firm: construction, business, and real estate. Those are kind of like the big three that I focus on, and most of my time is spent on. Insurance coverage is definitely a fourth that follows those, and I know insurance coverage, it sounds extremely broad. A more specific example of that are, you have a leak in your house, you make a claim to your insurance company saying, here are all the damages, please cover it, and the insurance company comes back and says, oh no, it's excluded because of A, B, and C, we're not paid for any of it. Or maybe they only are paying for a small fraction of it. That's when I can come in and I can help them, number one, guide them through the policy and read it myself to see, I don't know, sometimes the insurance company is right and it is excluded. More often than not, there are arguments to make as to why they're just trying to get out of this and they should be paying. So I help the claimant, the insured, go after their own insurance carrier, try to get them paid on a claim that should have been paid. And then last but not least, personal injury. Not something I talk about too much, but it is something that I do. So if anyone has ever, or knows anyone who is ever injured in a car accident, slip and fall, whatever it might be, I can help them out as well. So today what I'm going to talk about, I talked about it a while ago. I think when I first joined the group several years ago, I talked about contracts. I think it would be a good idea to kind of circle back around on that. We have a lot of different members now since when I first started. So I think it would be beneficial for most of you. Again, mostly everybody in here are contracts. For those of you who are not, I guess you guys can go to sleep or something. I don't know if this is too relevant for you. But since this is a construction group, I figure we talk about contracts, and I try to, when I speak, not every time, but do something a little bit educational, you would say, because for all of you contractors, you guys, can talk about all your projects and all these cool things you do and show pictures. With my line of business, I can't really do that. I don't have anything too exciting to talk about. So I figured I might as well do something that's relevant to our group, at least mostly. And if I can provide any sort of education, I will. So we're going to talk about requirements for construction contracts. What I'll talk about today are the just basic, these are the things that must be in a contract to be in compliance with the CSLB. And if you don't, if somebody complains, you can get fined, disciplined. So these are just the bare minimums. There obviously is a lot more that me as legal counsel would recommend, but this is the bare minimum. As going through this, I didn't realize how many slides this was, and there's a lot of information in here, so I'm not going to go word for word or we'll be here forever, but we'll just go through it quite quickly, the basic bullet points. So again, any contract that's for work that's $500 or more, or any work that's for $500 or more requires a written contract under the CSLB, which most of the stuff that probably you guys are all doing is like that. I mean, there's smaller jobs replacing something, maybe not, but most construction work is going to require a contract. It has to be in 10-point font. It has to have the date it was entered into, and there has to be an address, license number of the contractor right there on that front page in the first paragraph. And again, the reason they want that address of the contractor in there on that first paragraph is because that's where the notice of cancellation would be mailed to. We'll talk about that towards the end of the presentation. But you do need to have a notice of cancellation, either a 3-day or 5-day in the contract, depending on how old your customer is. So that's got to be in there to show if you need to cancel, this is the address to send it to. Then other thing that needs to be in there is that if satisfactory work is done and upon payment for that work, then you have to give them a lien release, whether it's a pool contract, whatever contract it might be. The law does require that statement to be in there. And again, you do some work, they're paid for it, lien release is the proper way to handle that. That language should be in there in the contract. CSLB requires it. So change orders obviously is something that you guys all deal with all the time. That's an important one. Some language should be in there regarding change orders, how they work, how they're incorporated into the contract. the procedure for that. The CSLB does not provide this is exactly what you need to put in there, but it's got to have certain information in there. So again, and the purpose of this presentation is, since we're not going to go through it word for word, there's a lot of it. If any of you or somebody that you know has any questions, have them reach out to me. I can help them out with this. This is something that we do, is making sure our clients have good contracts that are in compliance with the CSLB, and in addition to the basic requirements, have the things that really should be in there to protect the clients. In close proximity to the signatures, there must be some information in there stating that the customer has the right to make the contractor have a performance or payment bond. Now that generally is on, their buck. If they want to have it, they'll pay for it, but there needs to be something in the contract that says that they are allowed to do that if they'd like. Again, talking about business address, license number of the contractor, that you're required of a completely filled in copy of this agreement. That's something that should be in there verbatim. Again, there are a lot of times that I will have a client call me and I ask them for the contract and it's not even signed, it's extremely sloppy, and again, does that make it or break it? No, but it makes it a lot easier for me when it's a good contract, everything is signed, it's fully executed, so nobody can make any arguments that, I didn't sign it, this and that. So that's a good business practice. Contract price has got to be in there, obviously, and that's got to be titled with that. If there are any finance charges, got to talk about it and title it that. Scope of work is always, something that needs to be in there. Again, doesn't need to be verbatim, this is every little thing that I'm going to do, every nail that I'm going to put in a wall, but it's got to say that, basics of this is what we're going to do for you. It can either be in the body of the contract, it can be as an exhibit. Generally, that's how I draft contracts, is I will make the scope of work as an exhibit just to not try to jam it in the middle of a contract. I think it's cleaner that way, but it can be done, either way. So approximate start end date, the CSLB does require for you to put this in. And again, it's approximate. As we all know, as you guys all do the work, I'm sure as we've all experienced maybe as customers, construction timelines can shift depending on what's going on. But you need to try to put something in there about a sort of timeline. I think approximate start date, generally you can try to be as accurate as you can. I know maybe if permits haven't been obtained yet, that is also, that can fluctuate. But the end date sometimes I feel like is difficult to predict. But again, you got to at least throw something in there. And again, those can always change, can be revised, but technically a timeline does have to be in the contract. Same thing or more about extra work and change orders. So this language, as I put it in quotes, this actually must be in the contract verbatim. It talks about how the change order or any extra work that's not encompassed by the original contract actually becomes part of the contract and therefore is enforceable. So you'd want this in there because if you do have change orders, which as we know happen all the time, you want to make sure those are enforceable and become part of the contract. So more stuff about change orders and extra work. These are just basic statements that should also be in the contract about, a customer cannot force a contractor to perform extra work unless there's a signed change order. That it's not enforceable against the buyer, so this is the other way around, contractor against buyer, unless it identifies all the things that is required. So change order must generally identify the scope of work, what is the effect of that price-wise, how did the price change? Usually price goes up, but I don't know, maybe things are being removed, maybe price is going down. Either way, that's got to be identified. You got to talk about what effect that'll have on progress payments, and if there's a change in schedule now due to all this additional work that's being done, that should be in the change order as well, to show this is what we're doing, this is how much the price is going to change, and this is how much the timeline is now going to change. Those are the things that are required. Again, want to have, technically by law, you need to have a signed change order, but even from a practice perspective, you want to get them signed, documented, everything, because it's much easier if we ever have to argue down the line that, there was all this extra work. Without a signed change order, it makes it a lot more difficult. We have to now look for other evidence to support that there was extra work and let's say it wasn't paid for. When you have a signed change order signed by both parties, makes it a lot cleaner, a lot easier. So let's make sure we're doing that. So down payments, this is one that you know, not a lot of people, I don't see this in a lot of contracts, and it, you know, sounds unfair, especially considering when you have a lot larger projects, but this is literally straight from the CSLB. You know, if you are going to charge a down payment, which a lot of people do, you got to have a title of it, you know, and a special space in the contract for it. And it's got to have this, and they require it in all bold, that the down payment may not exceed $1,000 or 10% of the contract price, whichever is less. Now, I know I've gotten a lot of questions of, well, I ask, you know, for a certain payment up front when we start the project. That's different. If you're already starting the project, we're on site and we're going, that's different. This is talking about like at the time of signing my contract, but we're not starting the job for another month, 2 months. Technically, you are not allowed to collect more than this. That's by law. But once you start doing the work, then of course you can collect the first payment and then move forward.
Do they require it to say down payments instead of deposit? Mine reads the word deposit.
So
instead.
if you talk about CSLB Business and Professions Code, down payment is the word.
Wow.
Yeah. You know, again,
What about the word retainer?
retainer's not anywhere in the code. It says down payment. I mean, again, let's say worst comes to worst, if this was ever to go in front of the CSLB, do I think you would be disciplined if you used a different word? No, I don't think so, as long as it means the same thing. But again, you want to go by the Business and Professions Code, this is the term that's used.
Elan, so at what point does the job start where you can invoice? So for example, if we have a project where I'm gonna buy, you know, $50,000 in lights for a rec center, right? And I need to do that the day after we sign a contract. Can I invoice for that on day of if I have to order the materials, like a materials invoice?
Correct, because now at that point, like you said, you are now incurring, for example, $50,000 in cost. So at that point, since you are doing that and that's for the project has technically started.
Okay, so if I'm invoicing Jessica $3,000 because we're gonna redo her kitchen and I'm gonna go buy all the materials, that's okay even if it's day one?
Correct. If you're gonna go buy the materials, you shouldn't be expected to, I have to incur all these costs, eat them all until I actually step foot on the project to install them, for example.
But that's after the $1,000.
Yeah,
Yeah, that's after $1,000 could be,
a month earlier.
yeah, it could be.
But if it's same day.
If it's same day though, right, if let's say we're signing the contract today and I'm ordering the materials today or tomorrow, then that could be simultaneously, so it depends. But this is for the purpose of, sometimes you sign a contract and nothing is done for months. The law does not allow you to charge more than that if that's the case. But of course, you're ordering materials right away, you should, you are able to get payment for that, of course.
I have a question.
Yeah.
Around the ordering process, do I have to order before assessing them an invoice, or do I have to invoice them after? I can invoice them for materials after
You can invoice them before, just, again, and all this is just if there was ever an issue that was brought up, you'd want to have a paper trail of it. So you can invoice them before, just the materials would need to be ordered like simultaneously or shortly thereafter, right? Not
Within a
a
business
month.
day.
Exactly, not a month later,
Right.
because then if someone sees that later, they'd say, oh my God, you collected all this money, but you just sat on it for a month and you didn't do anything with it. So that's what they want to make sure, that you're collecting the money and it's being done.
Sounds reasonable.
Yeah, it's actually being put towards either materials or actual labor, whatever it may be.
So in that scenario, it's not, oh, here's your invoice. It's, you gave me the money, and how much time between the time you gave me the money and when I ordered that really matters.
Exactly. They want to know that you're not just sitting on a customer's money and it's just sitting with you and nothing's being done with it.
Right.
One last question. If I have inventory and I'm going to charge them the material cost for my inventory, is that reasonable?
That is reasonable because again, it is still for materials. It's not just I'm pocketing this money and it's just sitting in a trust account doing nothing with it.
Do the materials have to be on the job?
They don't have to be on the job, but they have to be for use of the job, and they have to be in the contractor's possession.
Okay.
Yeah.
Or pending?
Can deposits be non-refundable? I had an instance where a customer signed the contract, gave me a deposit, and then somebody else came in behind me and completely cut the legs off my quote. And they undercut me massively, and then they unwound the whole contract.
So as long as it's within those parameters, 100%. There's no law that says, if they decide to back out, you have to give them their deposit back. So you can make it non-refundable, it just got to be within those parameters.
Maybe make a little bit of a tweak to that one. So like, if somebody, let's say has to consult, an engineer, other specialists, and they spent the money for that, it would be reasonable to not be expected to refund those costs, right?
Correct, yeah. I mean, if there's been actual work done, time expended, yeah, you don't have to refund for that. If it's, hey, I signed a contract, I've done nothing, I just sat on it, and then they came back and said, I want out, then again, if in the contract it says it's non-refundable, let's say it's $1,000 or 10%, whatever it is, then it's non-refundable. It is what it is. But yeah, if there is additional work that had been done during that time, then yes, you have a right to compensation for it. I mean, the CSLB, from a legal standpoint, what I see is pretty fair. I mean, it's pretty common sense that if you do work, you buy materials, you're entitled for compensation for it. They just want to make sure no one's being taken advantage of, for the most part. Progress payments, this is another important one. It's talking about money, and that's always a big one. So you need to have a section in your contract. Again, if there are going to be progress payments, which in most, at least bigger projects there are, it's got to be titled Schedule of Progress Payments. Got to make sure you put in there, either dates that payments are due, or let's say milestones. After I complete this work, then this is going to be paid. That should all be set forth in the contract. But then at the very bottom there, I know in really small writing, again in quotes, this language should be verbatim put into the contract. It's required by the CSLB, which, in summary, it's pretty much what we just talked about, that you need to put in how much is owed, when it's owed, this and that. About insurance, so the CSLB does require for information about general liability insurance. You got to have some information in there. Again, if you don't carry general liability insurance, that's just got to be in there. It's not, you don't have to, but you got to put that in there. If you do carry insurance, you got to put in there that you do, for what insurance company, and then you don't have to put in your insurance information in the contract. That here's my insurance company policy number, limits. You don't have to. You can, but you just at least have to say what insurance company with, and that the customer may call them if they would like. If you're self-insured, you got to put that in there. Just got to make sure put some of this in, whichever one applies to the contractor, it's got to be in there. For workers' comp, it's pretty much same thing. Maybe there are no employees, so they don't have workers' comp insurance. That's just got to be stated in there. For most that do it with employees, you got to put in there that you actually carry it. So some warnings that are required to be in contracts, they mainly are surrounded around mechanics liens. Again, I wasn't going to take up 10 slides to just copy and paste from the Business and Professions Code, but there are exact language that you need to put in your contract regarding mechanics liens. They're really long, but it just really explains to the customer or the client what mechanics liens are, how they work, how to avoid them. So you want to make sure that stuff's in there. So if you ever have to move forward and use the lien process, they can't go and say, oh, my contract didn't say anything about it, or you didn't have the required language, because that could be used potentially to defeat a lien. So it's simple. That stuff literally copy and paste. So we want to make sure it's in there. Just basic warnings, stuff about licensed contractors, warning everyone about only using licensed contractors, because if you are unlicensed, customers kind of out of luck. You can't go to the CSLB and complain, oh, my contractor isn't licensed. The CSLB is going to say, well, that's why you should have hired a licensed contractor, because we don't really have any jurisdiction over unlicensed contractors. We can't do anything. If you want to go sue them in court, go ahead, but we can't do anything about it. That's why it's important to hire licensed contractors. So, you don't necessarily have to go sue anybody. You can go to CSLB and there's things that they can do. So there's some warnings about that as well. 3 to 5 day right to cancel. Okay, I talked about this in the beginning. You need to have the address in there at the beginning of the contract of where to send the contractor a notice of cancellation if necessary. Again, most contracts are going to be a 3-day right to cancel. 5-day right to cancels come into play when you have a customer who's a senior citizen. And again, there's specific language that needs to be put in there as to the notice of cancellation. I wasn't going to put it all in here, but it lays it out for us what needs to be in there. It's got to be 12-point font. It's got to be at the end of the contract where the signature lines are. So as they're about to sign the contract, I mean, that's the purpose at least, as they're about to sign it, they read this notice of cancellation, okay, these are my rights, I have X amount of time to cancel this contract. And then again, owner's gotta sign that, acknowledging receipt that I saw this, I agree to it. So that's gotta be in the contract as well. Next
So,
slide.
question on that, you signed the contract, and right there, you take a check for $50,000 for the lights, do they still have 3 days to cancel that contract?
So they do, but if they know that, or you have to put them on notice of, okay, the second you sign this contract, I'm gonna go order $50,000 in lights, let's say. If they have that in their possession, then it can become non-refundable. But if they don't know that you're gonna go buy all these lights within, immediately, then that could become an issue. Because again, the law does state that people do have depending on what age, 3 to 5 days to cancel. So if you're gonna do that, I would just be very cautious of making it very apparent that I'm going to buy this stuff right now. So even if in 3 days you go cancel it, I might be out all this or a portion of it, and I would expect to be recouped for that.
Right.
What is the definition of a senior citizen?
At what age?
I'd have to, I have to take another look.
60.
I think it's 60.
Really?
Yeah.
Any customer you have today is a
Yeah.
senior citizen.
Maybe, you might be right, I know. I'd have to take another look at the
I don't
code.
think of myself as a senior citizen.
well, I guess you
It
are.
might be 60 or 60.
Really messed with my head right
Well,
now.
Yeah.
just think about who's got the money. It's the
Yeah.
people,
Yeah.
that's right.
I think
The
or
baby
it could
boomers.
be 65. I'd have to take another look to see what the exact age is, because it's changed. I'd have to take another look. So I'll look into that.
That's
I'll get back to
valuable
you.
information.
Yeah, I definitely will. So just more information on that. It has to be written in the same language as principally used in any sales presentation. And again, it's got to be 12-point boldface font, and it's got specific language. This is just a snippet of the specific language. There's a lot more that goes with it, but we pretty much just talked about it. So here are some specific recommendations that I would put into contracts. So these are not requirements by CSLB. These are, if a client comes to me saying, can you draft me a contract? I'm gonna say, let's make sure we put these things in there. Attorney's fees provision. I think that's extremely important. And that's one of the things I always ask if a client comes to me saying, I have this customer that's not paying me, can we go after them? My first question will probably be, well, what amount is at stake? So I need to know, is it a couple $1,000 or are we talking about something more substantial? Because if we're talking about a small amount of money, then I would say, to be honest, you're probably gonna pay me the same amount that you would go get, or maybe even you're gonna pay me more than what you could get. So it doesn't really make sense for you to throw good money at bad and hire an attorney to do this, maybe taking the small claims. I don't know. I'm always gonna have that discussion with my clients because, I'm always honest with them on how much money, they could potentially spend. So I always wanna know, what are we going after first? And the second question would be, is there an attorney's fees provision? Why? So an attorney's fees provision, just a brief summary, is something along the lines of, in the event of a dispute between the parties, the prevailing party has a right to recover their attorney's fees and costs. So if there's any kind of claims, lawsuits, the winner of the case can recover the money that they spend on their own attorney. So obviously I ask that because I think, well, yeah, you're gonna have to pay up front for an attorney, but we can get it recovered on the back end. If there's no attorney's fees provision in the contract, then there's nothing you can do. California specifically says the only ways you can recover attorney's fees are if a statute provides for it, or if there's a contract between the parties that allows for it. For construction work, really, there are no statutes that just provide for attorney's fees. That's why you gotta have it in the contract. General contractors, you wanna have an indemnification provision for your subs. So you wanna have a provision in there that if you're ever sued due to somebody else's work or somebody else's negligence, you want to have something in there that they have to, indemnify, defend, and hold harmless. That's important in there. We talked about payment schedules. Responsibilities of the parties, I think that's another important one. Talking about, obviously, the contractor ones are pretty simple. You have to do good work, provide a crew, be on time, this and that. But the owner also has responsibilities. If there are maybe some hidden conditions in the house that they would know about or underneath the ground, it's their responsibility to notify the owner of those things. So to notify the contractor of those things so the contractor knows kind of what's happening. So there are some responsibilities on the owner of the property. I would put that in there. Change orders we talked about. Termination procedures, that's a big one. Sometimes, things go south, you got to terminate a contract. I think it's important to have in there on what grounds both a contractor and a property owner have to terminate a contract, and what the procedure would that be for that, and what effect would that have. Usually there's still money outstanding. What happens with that? I think it's important to lay that out in the contract, because when nothing is stated in the contract, that's when things get really murky, because no one really knows what's supposed to happen. It's everyone arguing over it. If you have a contract that says, no, here it is, it's laid out, it's a lot easier generally. A dispute resolution, and this is another one, and we'll talk about it in the next slide. I would have something in there of how disputes are resolved. A lot of things nowadays go to arbitration, because arbitration is a much quicker process, generally less expensive. So most of my construction contracts, I put in there that any disputes have to go to arbitration, but first they need to be mediated or try to be resolved informally. So if you don't have anything in there, then they can just go sue you in Superior Court, which is a similar procedure to arbitration, but it takes a lot longer. Arbitration you have a lot more control over. If you're going to have an arbitration provision in your contract, which states that, if we have to go there, you cannot file a lawsuit in the Superior Court, we have to take this to arbitration. There are really strict requirements in California on what needs to be in the contract in order for that to be enforceable. It's got to be titled Arbitration of Disputes in all caps like it's written there. It's got to be in minimum 10-point Times New Roman bold font. And then there is a huge paragraph of exactly what you have to put in there. I wasn't going to copy and paste that, but to sum it up, it's telling the customer that I understand I am waiving my right to a trial by jury, and that any disputes will be settled by a neutral arbitrator. It will be binding. There will be no chance to appeal. Stuff like that. It's just making it really, really clear for the customer of what the heck arbitration is, so they can't ever go back and say, I had no idea what this is. But if you do not have this and that language that I just talked about in the contract, the arbitration provision becomes unenforceable, and California courts have constantly ruled that. They're really strict on it. So it's on the contractor to make sure the right language is in there, or else it's kind of null and void. So that's something that's pretty important if that's something that we want to put in a contract.
They don't require like a separate initialing for that section?
So there is, at the bottom you got to have an initial line. It doesn't have to be a separate document. It can be right within the contract. But at the bottom you would put initials of the owner and the contractor to put in there, kind of giving your assent to the arbitration provision. I think that's it. I know it's a lot of stuff that we went over, and again, there's a lot more. But this is one of the services that we provide for our customers. We draft contracts from scratch. We will, update our clients' contracts. Maybe they haven't been looked at in a long time, making sure they're in compliance with the law.
Why don't you say something quickly about preliminary notice?
Preliminary notice. So I'll move on in 1 second. And this is kind of why you guys see how much information I just threw at you in 15 minutes. And again, this is not all of the language that needs to be in there. These are bullet points, a lot of them. And this is exactly why when somebody calls me and says, can you just draft me a quick 1 or 2 page contract? And I just tell them I can't do that, because
sounds like 5 pages.
Easy. Just if you take just what's required by CSLB, you'll be at 5 pages. So, I tell them, listen, I don't need to write you, like, the gentleman was saying, a 50-page contract. It doesn't have to be that. But I can't give you a 1 or 2 pager because I can't even get what's required in there. Plus, there's some things that I would recommend. So that's why when somebody says, hey, I'll pay you for an hour at a time, draft me a contract, I say, I can't do that. It's impossible. So that's just kind of, something on that. But like Pierre was saying, preliminary notices, that's obviously going with the lien process. So with respect to preliminary notices or mechanics liens, general contractors, or the prime contractor as the law calls them, they don't have an obligation to serve a preliminary notice on the homeowner. Why? Well, because the homeowner knows that the general contractors obviously working on their house. They're the ones that hired them. They're the ones that contracted with them. So the purpose of the preliminary notice is for the property owner to know who is working on their house or property, and therefore who has lien rights. So if you're a subcontractor, material supplier, anybody that falls into that, you have a duty to serve the property owner and the general contractor with a preliminary notice within 20 days of starting work on the project. So a good practice would be that any project that you go on and you're a subcontractor, material supplier, serve a preliminary notice. I mean, I guess if it's with a GC that you work with forever and never had any issues, you don't have to, but it's a good practice. There's nothing wrong with it. All it's doing is preserving lien rights if you ever have to enforce it. So that's within 20 days, and then at that point you now have lien rights and you can move forward with the mechanics lien. But if you don't have the preliminary notice, can't do anything from there.
What if the job only takes 5 days?
Well, then you just got to make sure you do it within the first 5 days. So yeah, if it's a quick job, that's fine. If it's more than 20 days job, make sure you do it by the 20th day. Anything else?
I mean, my standard practice is I just make sure I get paid. I mean, if a 5-day job, I require middle payment. Otherwise, I'm packing up.
Exactly. If it's a 5-day job, yeah, I mean, you're gonna get paid. You're not gonna get paid. If for some reason it drags on, make sure you serve the preliminary notice just to preserve your life. But yeah, I mean, your lien rights. But yeah, that would be the best practice. So.
Chargebacks, does that happen to any of you guys? Chargebacks.
The change orders.
No, I'm saying chargebacks. They pay by credit card,
Okay.
and then they contest the charge.
Happened to me once.
Oh, that's
How
fraud.
do you handle that?
No, well, they can dispute the charge.
Well,
And
yeah.
then
Yeah, but they get it immediately. You have to prove that you did the work to their satisfaction.
Well, technically, I would think that would fall under credit card fraud, is your intention, doing that with the intention of doing that.
Yeah, I mean, again, like you said, how do you deal with it? It's just, you're contacted by them and you have to show them,
You have a
providing-
great company that can supply services.
Mhm.
Internal, that's
Yeah.
internal.
Yeah.
Peter?
I was wondering, you're going over this, you've gone over this a million times in contracts, and I can tell by the way, this is all routine for you. It has to be more exciting to litigate something like this.
Yeah.
Yeah,
Yeah, I mean.
You have to take your client to court, but I mean, just for your own, I don't know, benefit or.
100%. I mean, when I get on an initial consultation call or meeting with a client, of course, the question is going to be at the end of me providing all the information, what's your recommendation? And I always tell the client, generally say to all, listen, I'm not the attorney, unless you have to, that's going to say, let's go file a lawsuit tomorrow. Unless, of course, there's like a statute of limitation issue or something and we have to. But reason being is because generally most disputes can be resolved informally by sending a demand letter, negotiating, so we don't have to just file a lawsuit right away. But I tell them, selfishly, I would like to go file a lawsuit tomorrow because number one, that's fun for me. And generally, an attorney makes more money if you're litigating because it gets way more expensive when it comes to litigating. But I say, because of that, it's not in the client's best interest. It becomes a lot more expensive. It takes a lot longer when you get it in front of a judge. But selfishly, that's what I love to do. It's not sitting behind my desk and drafting, contracts.
I've given him some great entertainment.
For sure, for sure. Like
we've had just an absolute. I've stimulated him. I've excited him.
Every hour of the day.
So have I.
Trust me.
Yeah.
This one goes nutsville, but we'll figure it out.
Yes.
Another thing too, if you use a contractor that you not usually work a lot with, make sure you get a material release. And a full release from them, labor and material. I was on a job and I used a roofer and I paid him and stuff and I didn't sign the release, material, labor and material. And several months later, the supplier of the roof material called me and said, well, we didn't get paid.
Wow.
Did they
That's
provide
messed up.
Did the roofing supplier provide a preliminary lien notice?
They didn't either.
Yeah.
But they
That's
were
where it
screwed
can
no
get
matter
sticky.
what.
I was just gonna ask, real quick, so I think anecdotally for a lot of folks in the room who are homeowners, they've, you know, probably contracted different people over the years. In my personal experience, typically when looking at those contracts, it has a lot of the features of, okay, it's describing the scope of work, materials, labor, start date, finish date, etc. But more often than not, a lot of the required disclosures simply either don't exist or they're not correctly worded. And so I think, you know, it might be okay if it's somebody that you've worked with for a long time and you have a relationship. You know, what is kind of your thoughts or advice on that? Of just, you know, a lot of contractors are not attorneys. Their contracts that they have are just, you know, not sufficient from dealing with folks like that.
Yeah, absolutely.
Exactly.
So what would be my advice for like the contractor or for the homeowner?
Each.
For each. Okay, I mean, I guess from a homeowner's perspective, if you know what, again, most people don't, you know, if you're just hiring a contract to do some work on your house, you don't know all of this stuff. So you're not really knowing what to look for. You just assume the contractor's contract is sufficient. If you do know this stuff, then, I mean, I would push back. I would say, listen, I'd love to move forward with your work, but can you please update your contract to make sure it's in conformity with the CSLB requirements? That would be my recommendation. And then the contractor might be out the door saying, I don't want to deal with this person because they already seem like they're a problem. But from a contractor's perspective, and again, that's mainly the side that I'm working on is for the contractor. That's why I just think it's really important to have, you know, an attorney, you know, draft a contract for them. And I know that we can find a million contracts on Google. I know they're out there, and maybe every once in a while you find one that's good. But it's you know, I can't say I've ever seen a Google contract that has everything of this that's in there. Maybe some of it, but not all. And again, for most people, they say, I've never had any problems. Listen, that's wonderful, thank God. But if you do ever have that one that becomes a problem, you want to make sure that, okay, I know my contract's legitimate and I'm not going to have any issues. So that's why I would just recommend it. Again, I can't put a gun to somebody's head and force them to do it, but it's definitely something that should be done, especially somebody that's been in business for a while. Thank you guys. Thank you.